Hello, I'm Timothy Sims, and for my final presentation, I'll be discussing the Sixth Amendment and the right to effective counsel. When the framers were constructing the Constitution, and especially the Bill of Rights, they were doing so with British history at the front of their mind. An important part of the history was the Star Chamber. The Star Chamber was a court of the king, but it was meant to act as a way to prevent corruption and to hold the powerful to the law. But in reality, it quickly morphed into a tool to push political opponents through secret hearings on trumped-up charges and achieve easy conviction. Which is why the rights of the accused are so explicitly protected in both the Fifth and Sixth Amendments. The clause of the Sixth Amendment that we're focusing on today is the right to have the assistance of counsel for his or her defense, and the jurisprudence that has developed surrounding this clause. For nearly 200 years, Americans had the right for the assistance of counsel inherent in because of the Sixth Amendment, but the onus for obtaining that counsel was on the accused or the defendant, which, due to the high cost of legal retainment, effectively deprived the indigent of the ability to enjoy that right, resulting in a huge disparity in the doling out of justice. Three cases laid the foundation for this right. Powell v. Alabama, decided in 1932, opened up the door for the indigent being provided counsel, but restricted it to unique circumstances such as in capital offenses cases or in cases in which the defendant or the accused could not defend themselves. Johnson v. Zerbst, decided in 1938, guaranteed the right to counsel for all in federal criminal cases, but because a vast majority of cases are tried at the state level, it wasn't until Gideon v. Wainwright in 1963 that this right was incorporated onto the states, and the majority of Americans and all Americans were guaranteed this right. So though these cases provided the foundation for establishing the right to counsel, what they don't address is the right to effective counsel. To me, the most egalitarian aspect of our judicial system is the right to effective counsel. This right, however, is very narrowly defined and has taken even longer to define than the general right to counsel. The foundational case in this jurisprudence is Strickland v. Washington. Strickland v. Washington was decided in 1984 and began when David Washington pleaded guilty to capital murder, and in his guilty plea claimed to be experiencing extreme stress and trying to support his family. However, his attorney did not perform the necessary due diligence to present Washington's case in the sentencing hearing. Without pertinent information such as character witnesses or psychiatric evaluation, the trial judge found the death penalty warranted due to a lack of mitigating factors. Eventually, the case made it all the way to the U.S. Supreme Court, and the court held in an 8-1 decision that Washington's actions were not tantamount to ineffective counsel, as the counsel conduct was not unreasonable and there was not enough prejudice to set aside a death sentence. Justice Andrew Day O'Connor wrote the majority opinion in the decision and established the Strickland test. The Strickland test says that in order for a defendant to claim ineffective counsel, the defendant must prove that their counsel's representation throughout the trial was unreasonable, that the unreasonable conduct of the counsel resulted in enough prejudice to affect the outcome of the case. The next case in effective counsel jurisprudence is Florida v. Nixon. Nixon was arrested and indicted for first-degree murder and recommended the death sentence. Nixon's counsel, Public Defender Corinne, decided the best defense strategy would be to indicate guilt in the trial and to provide a case for Nixon's mental instability and plead for his life to be spared in the sentencing. Corinne attempted numerous times to broach the subject, but Nixon remained unresponsive and refused to give approval or disapproval for his defense strategy. Eventually, Nixon was convicted and sentenced to the death penalty. On appeal, Nixon argued that his counsel conceded his guilt against his express consent, and that amounted to an ineffective assistance of counsel. The Florida Supreme Court ruled in favor of Nixon and ordered a new trial. They reasoned that Corinne's concession of guilt in trial amounted to a guilty plea, obtained without consent of the accused. Eventually, this case made it all the way to the U.S. Supreme Court, where the court issued a unanimous decision reversing Florida's decision. Justice Ginsburg wrote for the majority, saying that the Florida Supreme Court erred by equating the counsel's concession strategy to entering a guilty plea. Instead, they should have applied the Strickland standard of does the counsel's representation fall below an objective standard of reasonableness. Nixon's refusal to respond left his attorney no choice but to act in the manner they thought best. One of the most recent cases in the effective counsel jurisprudence is McCoy v. Louisiana. McCoy's attorney and public defender was so convinced of McCoy's guilt in the murder of his 3 family members that he considered McCoy's best strategy to avoiding the death penalty was to admit guilt to the jury on all 3 counts and plead for mercy on the sentence based on McCoy's mental incapacitation. What differs this between Nixon v. Florida is that McCoy completely disagreed with this strategy and made it well known to his attorney and to the court. Eventually, the jury convicted McCoy on all 3 counts, and despite his attorney's pleas for mercy, they offered down 3 death sentences. On appeal, the Louisiana Supreme Court sided with McCoy's counsel, holding he had the authority and justification to admit guilt in trial in accordance with the Louisiana Rule of Professional Conduct, forbidding attorneys from committing perjury. However, when it reached the United States Supreme Court, Louisiana's decision was overturned in a 6-3 decision, and a new trial was ordered. Justice Ginsburg authored this opinion as well, stating that McCoy's attorney had violated his Sixth Amendment right by violating his autonomy, or ability to make decisions in regard to deciding the objective of the defense. McCoy's counsel had created a structural error by admitting McCoy's guilt in the trial, and it inevitably influenced the outcome of that trial. Justice Ginsburg emphasized that the attorney's job is trial management, not making fundamental decisions about the defendant's own defense. So while the Sixth Amendment has helped to create a more egalitarian and just judicial system, it cannot completely eliminate inequality inherent in obtaining effective and competent counsel. Jurisprudence surrounding the right of effective counsel shows that this constitutional guarantee is not unlimited. The Strickland test has set a high bar for bringing effective counsel claims, and is especially so if evidence is overwhelming against the defendant and the case's outcome was unlikely to be altered by the defense's strategy. Thank you.